Senator Aaron Cheriot, serving as the Senate leader of the majority party, and Senator Stuart Mazayo, as the leader of the minority party, want the House to call upon the National Assembly to expeditiously consider the presidential memorandum pursuant to Articles 115, subsection 2A, that all government ministries, departments, as well as agencies and constitutional commissions, including a parliament, to put in place austerity measures in undertaking their respective functions. The other issues is that the Ethics and Anti-Corruption Commission, EACC, and other government multilateral sector agencies in matters governance, justice, and law, and matters other sector, to upscale and make concerted efforts to fighting issues to do with corruption. The other issue the House wants addressed is matters to do with abductions. With the National Police Service do seize abductions, unlawful arrests, extrajudicial killings, and increase as well as exercise restraint in dealing with peaceful and unarmed demonstrators. The National Police Service is also required to release all persons arrested for planning and participating in peaceful demonstrations relating to the enactment of the finance bill. The government is equally required to waive hospital bills for persons who have been injured and defray funeral expenses for those who lost their lives during the demonstrations, and that the judiciary do prioritize and expedite all court cases relating to the enactment of finance bill and the resultant of the demonstrations. The House also wants the national government to make the consideration of all the challenges facing the country and make necessary recommendations to address them. The report of the Select Committee on Delegated Legislation on its consideration of the Social Health Insurance General Regulations of 2024 and the Social Health Insurance Tribunal Procedure Rules of 2024 is a motion by the Chairperson, Select Committee on Matters of Delegated Legislation, Honorable Mwenda Gataya, popularly known as Mofaya. In this particular motion, the Committee on Delegated Legislation, through its chair, wants the Senate to adopt its report on its consideration of the Social Health Insurance Regulations of 2024. The committee already laid its report on the table of the Senate on the 2nd day of July 2024, and that pursuant to Section 18 of the Statutory Instruments Act of the Senate, do resolve that the National Health Insurance Regulations of 2024 and the Social Health Insurance Tribunal Regulations of 2024, legal notice number 48 of 2024, be considered by the House. The business is just about to commence at the Senate. Senate Speaker, Honorable Amason Kingi, is presiding over the business this afternoon. Allow me to hand you over for this live broadcast, brought to you by KBC in partnership with PBU. Enjoy your viewing.
Waongozi katika jambo hii yetu ya Kenya. Tukuomba tuwajalie tuyatende na kufikiria mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen.
kisiwani Mombasa katikati mwa jiji. Na walikuwa ni vijana kadhaa, na sasa maafisa wa polisi naona wanaingia katika mojawapo ya vichochoro pale ili kuhakikisha kwamba hakuna maandamano yataendelea katika kisiwa hiki cha Mombasa. Hapa tulipo ni maeneo ya Kenyatta Avenue.
The Speaker of the Senate, Honorable Amason Kingi, currently presiding over the business of the Senate, this afternoon has directed the Sergeant-at-Arms to ring the quorum bell this afternoon, owing to the fact that pursuant to the standing orders of the House is not properly quorated. We need at least 15 senators in the chambers this afternoon for the House to commence business this afternoon. And as we await to see if that number will be attained this afternoon, allow me to take you through the other agendas for consideration this afternoon by the House, where away from the motion by the Committee on Delegated Legislation on its consideration of the Social Health Insurance Regulations of 2024 and the Social Health Insurance Tribunal Procedure Rules of the year 2024, the House will equally resume debate on the Houses of Parliament Bicameral Relations Bill, this being a bill from the National Assembly, Bill number 44 of the year 2024. The Public Finance Management Amendment Bill, Senate Bills number 40 of the year 2024 by Senator Hamida Kibwana, is equally another bill set for a resumption of debate this afternoon. The Street Vendors Protection of Livelihood Bill, Senate Bills number 41 of the year 2023 by yet another nominated senator, Senator Esther Okinyuri. And the Constitution of Kenya Amendment Bill number 2 of the year 2023. This is Senate Bills number 52 of the year 2023 by Senator Achimera, another nominated senator. In that particular bill on the Constitution of Kenya Amendment Bill number 2, before we look at the bills in the details, the Heritage and Museums Bill, Senate Bills number 8 of the year 2023, is another bill lined up for debate this afternoon, and so is the Agricultural and Food Authority Amendment Bill. This is Senate Bills number 13 of the year 2022. We'll be having a couple of reports set for tabling, and among them is the annual report of the Parliamentary Service Commission for the financial year 2022-2023. This will be done by the Senate Leader of the Majority Party, and the Senator for Nyandarua County, Senator John Methu, will be pursuant to Standing Orders number 53, subsection 1 of the Senate, be seeking a statement from the Standing Committee on Matters Health concerning the state of health and the health sector in Nyandarua County. Another motion lined up for debate this afternoon is the report of the Standing Committee on Matters Health on the inquiry into the alleged irregularities in the procurement of long-lasting insecticide. These are treated nets at the Kenya Medical Supplies Authority. This will be done by the chairperson on the Standing Committee on Matters Health, Senator Jackson Mandego, whose committee, through the chair, wants the Senate to adopt the report of the Standing Committee on Health on the inquiry into the alleged irregularities in the procurement of the long-lasting insecticide treatment and treated nets at the Kenya Medical Supplies Authority, KEMSA. The Committee on Matters Health already tabled its report on the table of the House on the 8th of May, the year being 2024. The House will this afternoon resume debate on a motion. This motion pertains to the report of the Standing Committee on Matters Finance and Budget on its status of the implementation of projects funded by the conditional grants for the construction of the county headquarters. The report of the Select Committee on the County Public Accounts on its consideration of the report of the Auditor General for the financial statements of West Pokot County Assembly for the financial year 2018-2019, as well as the reports of the Auditor General on the financial statements of Isiolo, Kiambu, Kitui, Marsabit, Narok, Nyamira, Trans Nzoia, West Pokot and Murang'a County Assemblies for the financial year 2019-2020 is another motion that the House is set to resume debate on this afternoon. The County Public Investment and Special Funds on its consideration of the Auditor General reports on matters pertaining the water service providers for the year ended 30th of June 2019, 30th of June 2020, and 30th of June 2021 is another motion that is set for debate this afternoon. The quorum has been achieved. Allow me to hand you over for this live broadcast. Enjoy your viewing.
Clerk, proceed to call the first order.
Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions. Order number 5, papers.
The majority leader.
Mr. Speaker, sir, I beg to lay the following paper on the table of the Senate today, 16th of July, 2024. This is the annual report of the PAC for the financial year 2022-2023. Mr. Speaker, I beg to lay.
Next order.
Order number 6, notices of motion. Order number 7, questions and statements.
Senator John Matthew. That statement is dropped. Next order. Okay. Order number 8 is deferred. Next order.
Order number 9, motion. Report of the Select Committee on Delegated Legislation on its consideration of the Social Health Insurance General Regulations 2024 and the Social Health Insurance Tribunal Procedure Rules 2024.
That order is deferred. Next order.
Order number 10, the Houses of Parliament Bicameral Relations Bill, National Assembly Bills number 44 of 2023, second reading, division.
That order is deferred. Next order.
Order number 11, the Public Finance Management Amendment Bill, Senate Bills number 40 of 2023, second reading, division.
The order is deferred. Next order.
Order number 13, the Street Vendors Protection of Livelihood Bill, Senate Bills number 41 of 2023, second reading, division.
The order is deferred. Next order.
Order number 13, the Constitution of Kenya Amendment number 2 Bill, Senate Bills number 52 of 2023, second reading.
That order is deferred. Next order. Now, Honorable Senator, we are now handling order number 13. That is the Constitution of Kenya Amendment number 2 Bill, Senate Bills number 52 of 2003. The floor is open. The Constitution of Kenya Amendment number 2, Senate Bills number 52 of 2023. If there's no senator willing to contribute, is the mover present? So we defer. Next order.
Order number 14, the Heritage and Museums Bill, Senate Bills number 8 of 2023, second reading.
The chairperson, Standing Committee on Labor and Social Welfare.
Mr. Speaker, not ready yet.
What do you mean you're not ready yet?
I've just got the paper.
It is your order. You submitted it to SBC. SBC has listed it for processing, for prosecution. Do you want to defer your business?
Yes.
Dara is deferred. Let's move to the next order.
Order number 15, the Agriculture and Food Authority Amendment Bill, Senate Bills number 13 of 2023, second reading.
Senator James Mrango. The order is deferred. Next order. Next order, clerk.
Order number 16, the County Hall of Fame Bill, Senate Bills number 18
of 2023. Second reading.
Senator Miraj. That order is deferred. Next order, clerk.
Order number 17, the Rice Bill, Senate Bills number 19 of 2023, second reading.
Senator James Murango. The order is deferred. Next order.
Order number 18, the Law of Succession Amendment Bill, Senate Bills number 20 of 2023, second reading.
Senator Veronica Main.
Honorable Speaker, thank you for this opportunity to debate the amendments that I have proposed on the Law of Succession Amendment Bill. Mr. Speaker, at the very onset, these amendments...
You need to move fast.
Honorable Speaker, I move that the Law of Succession Amendment Bill 2023 be read a second time. And Honorable Speaker, at the very onset, the purpose of this Law of Succession Amendment Bill is to amend the current provisions under the Law of Successions Act to align it with the current marriage and matrimonial property laws. And the bill also proposes to safeguard gender equality in the succession matter so that widows and widowers have equal rights upon the demise of a spouse. Honorable Speaker, at the very onset, we need to take note of the fact that the current laws of Succession Act have not been in tandem with the matrimonial properties law and have not been in tandem with the current marriage laws. Why do I say this, Mr. Speaker? Because if you look at the Kenyan, the jurisprudence in Kenya, or the legislative jurisprudence in Kenya under the marriage laws, you will find that we have a monogamous system of marriage which is prevailing. And in this monogamous system of marriage, it defines who is a wife. It defines who is a husband, Mr. Speaker. And it defines a monogamous marriage as that marriage that is of one man, one woman. But when it comes to current practice, Mr. Speaker, you will find that even in situations where a man is married under the monogamous laws, you find there is either another wife who is under the traditional system or polygamous system, and you will find that there are children that may emanate from such relationship. On very worst scenario, Mr. Speaker, you will find that maybe a man who is married to one wife under monogamous laws of marriage also has mistresses and has had children or has had children out of wedlock. What has happened then is a sort of what I would call a chaotic platform on how determination of rights under succession law then happen to experience, because peradventure, if that man departs from this world, Mr. Speaker, you will find that even children who are born out of wedlock cannot then become inheritors of the estate of that man. So you will find the very, would I say, famous scenario of the little boy child in black suit and bow tie showing up in a funeral, Mr. Speaker. And for the first time, the family of this man experiences other children who are claiming from the man, purporting that the deceased was their father, Mr. Speaker. in many instances you discover that actually those children could belong, their paternity can be traced to the man who has departed. So the purpose of this law, Mr. Speaker, is first of all to determine what should happen to children who are born out of wedlock. And number two are the women who have given birth to these children entitled to the estate of the man who is now deceased, Mr. Speaker. And because the law of succession, on the other hand, recognizes monogamy, recognizes polygamy, recognizes children who are born out of wedlock, recognizes other beneficiaries who may have been dependents of the deceased, then, Mr. Speaker, what has happened is that we have had a clash of laws between monogamous laws and the succession laws. So the purpose of this amendment is to align some of those areas. Mr. Speaker, it's also to look at the Children's Act and look at the Constitution, what the Constitution provides for children, whether children, once they are born from a certain lineage and from a certain paternity, are those children as entitled as those who are defined as children under the monogamous law. So, Mr. Speaker, in Section 3 of the Succession Act, that is the principal act, we are proposing, Mr. Speaker, an amendment to redefine who a child is. That child to include an adopted child, and that child to also include a child who is conceived during the lifetime of a deceased person and is subsequently born, even if they are born after the death of the deceased person. What does that mean? That if a man was to pass away, when the wife is pregnant, or not even the wife, or even a woman he impregnated, then if that child was conceived by the person who is deceased, Mr. Speaker, or departed, then it means the definition of a child will now include anybody who carries his DNA, Mr. Speaker. Is that important? If we look at the Constitution, Mr. Speaker, a child who carries the DNA will be defined in the Constitution as a child belonging to that person or to that man, and will be entitled to be an inheritor of that estate, notwithstanding that his father passed on. So we'll be seeking a redefinition to be more inclusive, and we're also looking at an adopted child, Mr. Speaker. An adopted child is that child whom the parents have assumed legal responsibility over. A court order has been issued, and that child is now defined to have adoptive parents who are then recognized through a full adoption process in court. Once that child is departed, they become equal or equivalent to the children who are born by the couple, or who are born by the man who has adopted them, or who are born by the man and the woman, or who are assumed, the parental responsibility is assumed by the man and the woman who have adopted, the couple that has adopted that child. So, Mr. Speaker, this definition now is expanded because even though the law had not expanded this definition, many lawsuits have been taken to court to define who a child is. So the law will now clarify that an adopted child should be treated as a child of that couple and should have equivalent rights with the biological child of that couple. Mr. Speaker, in the Principal Act, there is now the term intermeddling, which is introduced, Mr. Speaker, and defined what it means. The intermeddling is in relation to the properties of the deceased. Mr. Speaker, our courts are replete with a lot of data of cases that have been brought before courts at the instance of offenders who are intermeddling with the estate of the deceased. And we know them, even where cases have not been preferred, even where disputes have not been recorded. Yet we know in many family barazas, Mr. Speaker, we have had instances where relatives who perceive themselves to be stronger than the widow, for instance, will intermeddle with the estate of the deceased. And Mr. Speaker, I think every single senator in this house has come across many cases, Mr. Speaker, where the property of the deceased person is interfered with, possession taken, the property is being disposed of, somebody else is trying to forge a title, even charging the property, or even collecting the rents or collecting any benefits that are emanating from such properties, Mr. Speaker. The concept now of intermeddling has been redefined better in these amendments. They have been redefined to mean taking possession of, disposing of, charging, receiving, distributing, leasing or using property of a deceased without authority under this act or any other applicable law, or even ejecting a surviving spouse or a child from the matrimonial home or matrimonial homes, Mr. Speaker. From the stakeholders' engagement we have received from different actors in this field, Mr. Speaker, they have even proposed that this definition should even be expanded further to include any act or any action of ejecting a surviving spouse or a child from matrimonial homes or matrimonial properties, and any other action that may be deemed to become unlawful as it concerns with dealing with the deceased person's estate. So that means it will no longer be business as usual once this amendment is enacted. If somebody intermeddles with the estate of the deceased, then it means there will be criminal culpability. It means there will be penal sanction, Mr. Speaker, so that those big brothers, and I apologize for using the big brothers because they are the ones maybe or male relatives who have really oppressed widows who are vulnerable and who are busy mourning their husbands, Mr. Speaker, can then now take a back seat and consider whether they can take the criminal sanction that will emanate from such behavior. And that would as well mean, Mr. Speaker, after these amendments are introduced and accepted and adopted, Mr. Speaker, as part of our laws and enacted as such, it will then mean that those widows who have cried for many days, who have been thrown out of their estates, whose children could have been thrown into the streets by other relatives, Mr. Speaker, that will become a thing of the past. We have seen on many occasions that widows will not only be thrown out of the properties, you will even find that some very treacherous relatives or distant relatives have walked in, carted away a vehicle, even carted away movable property, carted away furniture, or even started commotion and very heavy fights, which are even evident in burial ceremonies, Mr. Speaker. So after this becomes law, it means that if somebody intermeddles with the estate of the deceased, then it means it is not going to be acceptable and they can be prosecuted for that, Mr. Speaker. Mr. Speaker, many lawsuits have been taken to court and not many people have been punished enough to send a message to the ones who are intermeddling with the estates, Mr. Speaker, that this should not happen. There are some estates in the Republic of Kenya, actually, which are notorious, Mr. Speaker, especially when you find an estate has many assets. I do not want to name them because of data protection, Mr. Speaker, but Kenyans would understand the number of estates which have become notorious for making headlines because of relatives intermeddling or taking shares that do not belong to them. Once this act becomes law, then, Mr. Speaker, it is going to be way better and this area will be settled. When this bill was read for the first time, Mr. Speaker, a number of people called me to congratulate and compliment the fact that Senate is thinking about amending these sections of the law because of the pain they have had to go through as they watched people who are not related to the man, the holder, or the deceased spouse to watch people who just come to claim. They claim things that don't even belong to them. They do not even know the deceased very well. But suddenly, Mr. Speaker, they come into intermeddle. And the intermeddling, Mr. Speaker, will also mean that any person who is entrusted with being an administrator of an estate of a deceased person will also have to be more accountable on how they manage the estate of the deceased. So this, Mr. Speaker, will debar any ambitious criminals and any person who would wish to take advantage of the fact that the man in that home is already demised and take advantage of vulnerable children. You have seen estates, Mr. Speaker. Some of them have only minors. Minors are left. Children who are under 18 years. Even before these children understand what their father owned, we have seen on many occasions, by the time those children grow up, the estates cannot even support their education. Those children who are being provided for, going to an ordinary school maybe, living in a good estate, or living in a sensible estate, we find all of a sudden the demise of their father or demise of their parent means that they can no longer enjoy the basic maintenance that they were being given by their parents. So it will throw a lot of cushion and a lot of protection to such vulnerable members of the family. Mr. Speaker, it proceeds on under Section 35 to be amended, Mr. Speaker, to enable that the interest of a surviving spouse to be determined upon remarriage. Mr. Speaker, if you look at the current Law of Succession Act, that interest only determines on the side of the woman. When a widow remarries, the interest in the estate is determined upon her remarriage. But the current provisions do not provide for that determination to be on the widower. It only determines on the woman's side. That means it's biased and not equitable to both genders. So the proposed amendment now, Mr. Speaker, is such that the interest of the estate shall determine for both upon remarriage. So that if the interest, for instance, if it's a widow who has remarried, because the interest would remain with the children of the couple before the man passed on, then it means even for a widower who gets married, that interest is determined. So it gives an equality in law, treating the man and the woman the same way. But in the current laws of succession, Mr. Speaker, it has not been treating the man and the women equally. That is the widow and the widower. So the introduction is for both of them, the determination is upon remarriage. Mr. Speaker, there is also another amendment where the surviving child is not a child of the surviving spouse. Where the surviving child is not a child of the surviving spouse, the surviving spouse shall be entitled to the personal and household effects of the deceased absolutely and a life interest in 1/2 of the whole residue of the net estate. And the surviving child shall also be entitled to 1/2 of the whole residue of the net estate, which shall be held in accordance with Section 41. And if there be more than one child, they shall share equally. Meaning, if for instance you have 4 children or 2 children, those children would share equally, and each of them you take a part. If there are 4, they take a quarter each. And a further introduction is where the surviving children include a child who is not a child of the surviving spouse. The surviving spouse shall be entitled to the personal and household effects of the deceased absolutely, and the net intestate shall in the first instance be divided equally among the surviving spouse and all the surviving children, and the surviving spouse shall have a life interest in his or her share and that of his or her children under the subsection that is cited there. And Mr. Speaker, a further amendment is that the share of the surviving child who is not a child of the surviving spouse under subsection 1B shall be held in accordance with section 41, and if there be more than one child, they shall share equally. You will notice, Mr. Speaker, the amendments are introducing an equality clause and treating all children the same way. Mr. Speaker, there is also another amendment under section 36 of the Principal Act. And Mr. Speaker, in this section 36, a lot of case law has determined that, Mr. Speaker, even after a spouse has passed on, the estate of that spouse will be held by the surviving spouse until the date when that surviving spouse remarries. But then, Mr. Speaker, in a scenario where both the spouses are not there, what happens to the estate? Now, in the current Law of Succession Act, that estate first goes to the father of the spouse who has passed on. What the amendments are seeking to introduce now is that such an interest, Mr. Speaker, will be shared between the father and the mother in equal measures, or if either is dead, the surviving parent. For instance, in instances where it was the father to take the net estate of the spouse who passed on, in these amendments, Mr. Speaker, it will now be the father and the mother to have that estate in equal. And if either of them is dead, then the surviving parent can have the share of the spouse who has passed on, or their daughter or their son who passed on. In the instant that there are no surviving parents, then the brothers and sisters. Before, Mr. Speaker, it leaned more towards a patriarchal tendency. It had a patriarchal tendency towards who holds the estate, the residue of that estate. What this amendment has now done is to put the brothers and sisters in equal measure, and any child or children of deceased brothers and sisters in equal shares. And this is important because, Mr. Speaker, you'll find sometimes the estates which are being distributed are actually not estates of the immediate parents of the people who are inheriting those estates. Sometimes you find even grandchildren are inheriting estates of their grandparents when there is no other surviving relative. And if it's half brothers, it is half brothers and half sisters, and any child or children of deceased half brothers and half sisters in equal measures. All the relatives who are the nearest degree of consanguinity up to and including the 6th degree in equal shares. So that when you have one generation, Mr. Speaker, which has all died, then it moves to the next degree, which is the next generation maybe of the grandchildren, and from the grandchildren it moves to the next step of generation. This is the one that is referred to as the relatives who are in the nearest degree of consanguinity up to and including the 6th degree in equal measure. What it has done, Mr. Speaker, this amendment, is to levelize between brothers and sisters, sons and daughters. And Mr. Speaker, just to assure you that these are the right amendments, if you look at the case law that has been generated from the courts, they have been more progressive than the legislation itself, because the courts have upheld now that the definition of a child is not just the boy child. It's a boy child and a girl child. So that, Mr. Speaker, if I have one boy and one girl, the law will treat them equally as my children, and none will have priority over the other. It's a very good amendment, Mr. Speaker, especially when you look at the population demography, because we have 50-50 or slightly more women than men. That means in any home, you will find their sons and their daughters, Mr. Speaker, and they are now being treated equally, a fact that has been happening in court anyway. And so what we are doing with this amendment, Mr. Speaker, is to ensure that what the law, the precedents have taken, the progression that the legal precedents have taken, Mr. Speaker, can be captured as correct legal principles applicable and making it more easier in distribution of the estates of deceased person. Mr. Speaker, the next amendment is under Section 40 of the Principal Act, and it has new subsection, a subsection 3, that notwithstanding subsection 1, where any of the surviving child is not a child of any of the wives of the deceased, that child shall be considered as an additional unit in determining the share of dependents in the net estate under subsection 1, and the share of such child shall be held in accordance with section 41, and if there be more than one child, they will share equally. The assurance that I once need to throw at this point is that it is the children who are sharing in the estate of the deceased. There was a bit of concern from women when they saw these amendments, because the women who happen to be, for instance, like myself, one wife, monogamous marriage, you don't anticipate another woman. They were very officially. They were a bit in a shock when they saw the amendments. I have seen how my brothers have laughed here, and they look like serious defendants for these amendments, Mr. Speaker. They look a bit guilty, Mr. Speaker, but I will interrogate each of them on their personal laws and their belief system and what they are keeping around them, the company they are keeping around them. Mr. Speaker, because when then a wife does not anticipate another woman coming to compete for the husband's attention or the husband's estate, Mr. Speaker, they were very concerned about this amendment. And one of the concerns was, are you now introducing strangers to our homes? Because the women, you feel these are strangers, but they may as well be strangers to the women, but not strangers to the men in those homes, Mr. Speaker. And I had to quickly assure that it is not the woman who is coming in for the estate of the deceased. It is the child who has been fathered through the paternity of that man. And what does that mean, Mr. Speaker? When a man now decides to keep an affair out there, they must understand the full consequences of that affair. That if you decide to father another child, you will bear the weight of that responsibility. Not just now, but even to the next level. And Mr. Speaker, Senator Boni Halwale is very vocal about this subject, and I will not disclose the number of wives he has. But Mr. Speaker, what this act of amendment is also doing is the fact that the Children's Act, as it stands right now, we all know how busy the Children's Court is right now, because any child who is fathered by any man, once the man fails to provide, they usually have a redress under the Children's Act. That is already happening, and maintenance is being done openly or secretly for those children, Mr. Speaker, who have been fathered by different potential defendants, maybe even in this house, Mr. Speaker. So what the law of succession is doing now, it's taking away the confusion that we have seen in burial ceremonies, in funerals. You see, when a person has passed on, there is another one who runs to court to stop the burial until issues are determined. It may as well be, Mr. Speaker, that when these amendments are effected, you will have less lawsuits of stopping burials, because, like we have always said, there may be no asset in a dead body, Mr. Speaker, but since many people may not understand that, they normally first run to stop the burial, saying that all the issues must be resolved. And part of the issues they will seek a resolution on, Mr. Speaker, will be how will the rights of this child be catered for, because this man lying in this casket is the father of this child. So what these amendments you do, Mr. Speaker, they can now pose anybody who is running to stop a burial and to know that there is legal protection for the child. not for the wife. Because in the law of succession, the law of succession has defined who a wife is. It has defined who is recognized as a wife and who is a wife. And if you are not defined as a wife, it is not possible for one then to push for a portion of inheritance from the estate of the deceased. But for the child, the law will now treat the child differently and in a fair manner, so that if the DNA of that child belongs to the man who is demised, Mr. Speaker, then it means provision has to be done. But is that child treated better than the other children who are in the officially recognized home? No, no, no. Mr. Speaker, those children will be treated equally. If it's education, they are provided for it. And that is provided for under the children law, the Children's Act. And Mr. Speaker, I know I've heard of this concept of gentlemen talking about nyumba dogo. Kuna nyumba kubwa na nyumba dogo. Now nyumba kubwa is the one which is the former one, Mr. Speaker. The one that is known by the public. The wife who is taken to the weddings, to church, to shopping. And then there is usually this concept of nyumba dogo, the one that is secret, unknown by everybody. And Mr. Speaker, what this will straighten, because the culture now could as well be very notorious in Kenya, Mr. Speaker. What these amendments you do, Mr. Speaker, is to ensure that we do not have children who are not being taken care of when their fathers are walking free and may be happy. And Mr. Speaker, because we should not be creating as a society despondency on these children, it is important that every child is taken care of, and every person who has fathered a child then takes care of that child and does not expect another person in another home to take care of their own DNA, Mr. Speaker. So it's putting the chips where they should fall, Mr. Speaker, that if you have sired a child, then take care of the child. So, Mr. Speaker, we are proposing this amendment, Mr. Speaker, and we hope that the backlog of the cases we have seen in the family law division, Mr. Speaker, is going to be sorted courtesy of better laws. And further, Mr. Speaker, is to say the case laws that are there are the ones that have inspired these amendments, that the courts have already been holding judgments and following precedents that are aligned to this amendment, Mr. Speaker. These amendments have been supported by many stakeholders, Mr. Speaker. The Widows Association have supported these amendments. FIDA Kenya has supported these amendments, Mr. Speaker. Different associations have supported these amendments because they are going to levelize the rights, protection of rights of the children. So, Mr. Speaker, a wife who is not a wife will not manage, Mr. Speaker, to claim anything under these new amendments. And we will eliminate discrimination against widows, Mr. Speaker, and sections 35 and 36 of the current Law of Succession Act have actually been found unconstitutional for discrimination on basis of gender, and therefore the bill also seeks to ensure that the widow and the widower have their life estate, their life interest in their estate, and it determines upon their remarriage, Mr. Speaker. And this is a very sensible amendment because, Mr. Speaker, for instance, if a senator, a woman senator passes on and maybe had a mortgage and bought a home, and she passes on and leaves the husband, and that home is left to the gentleman, if this interest does not determine when he remarries, Mr. Speaker, there could be a possibility that even that home will no longer be used for the children of the widow when she passes on. Now, this law will ensure that such a home will now not be left with the interest of the widower, but will be left in trust for the children children of the woman who has passed on, Mr. Speaker. And that means it's going to bring justice and a lot of equity, Mr. Speaker. I know there is one question that pens about matrimonial property. Supposing a property was defined as a matrimonial property and a man has passed on, and that property was determined and the widow now has remarried. And in that matrimonial property, for instance, and in line with the judicial precedent that was held by the Court of Appeal, I don't remember the name of that lawsuit, Mr. Speaker, from on top of my head, the woman has contributed, say, 30%. What you determine at the point when this man remarries is the portion in that matrimonial property which belongs to the woman. The portion that belongs to the man who is now a widower will still be retained by the man. But the 30%, for instance, if the woman would have demonstrated to the court that 30% of that property was contributed to, and she was entitled to an apportionment of that 30%, that 30% will then determine in favor of the children of the woman maybe who has passed on, or the man who has passed on. So this law does not seek to bring inequality, but it seeks to bring equality, Mr. Speaker. I also wish to note that the court had previously found Section 39 to be unconstitutional insofar as it gives the fathers the priority when it comes to inheriting the property of their deceased children. It now means that the father and the mother of the deceased child will be able to inherit. Notably, Mr. Speaker, there is a section in this bill that has excluded community land from the ambit of succession. You know, in some counties, there are some counties where community land has been excluded from the family law and succession. For instance, in pastoralist communities and in counties like, say, West Pokot or parts of Kajiado, where there is community land that is for grazing, it cannot be subjected to the terms of this, to the provisions of this Law of Succession Act. That means the amendment is still not breaching the rights under community land, and the community land continues to be protected and out beyond the ambits of these amendments. Mr. Speaker, I would pray and hope that my colleagues, the senators in the House today, would find the sense in the proposed amendments and would support them, so that, Mr. Speaker, we can then say spouses, surviving spouses and children will no longer be ejected from their homes, matrimonial homes, when their father or their mother has died, and that instead of them being ejected, we will see more compassion from the society, we will see more compassion from the relatives who have, in other instances, taken advantage of such vulnerable families, Mr. Speaker. And ejecting would mean, Mr. Speaker, if the definition is opened, would mean, for instance, that even persons who interfere with accounts, for example, Mr. Speaker, supposing somebody had access to accounts of a deceased person, I don't know, for some reason, in many families, Mr. Speaker, when you find disputes within the family, you find even spouses are entrusting outsiders with their resources. They entrust them. They make them attorneys to sign bank accounts, and they cannot even entrust their wives with the signing of those bank accounts. The intermeddling will mean, Mr. Speaker, that even a person who has access to sign accounts for that man or for that woman, and after the demise of that man, they decide to clear that account, Mr. Speaker, this act will still be able to reach out and punish, Mr. Speaker, any such actions, Mr. Speaker. There has been a debate on what should be the penalty of a person who then intermeddles with the property of the deceased, Mr. Speaker. And I'm sure, Mr. Speaker, when we come to the Committee of Whole, we look into the appropriateness of that account, because finding 10,000 is not good enough. I'm aware that JLAC should have presented a report, which is still coming, but I was duly advised, Mr. Speaker, that the report can come now, or the report can come even after, even during the second reading. It can still come, Mr. Speaker, because it will inform the debate, and I'm sure the chair of JLAC, who is here, will be putting his comments on these amendments, Mr. Speaker. So by and large, Mr. Speaker, these are good amendments, and it is my hope and prayer that senators will support these amendments and will clarify the issues that have been bringing a lot of pain unabated for very many years, so that we can have more sense into the distribution of the state, protection of children's rights, protection of women, gender equality in terms of succession, Mr. Speaker, treating mothers and fathers of deceased children the same way, Mr. Speaker, and we'll be able to make progress in the area of family law and succession. With that, Mr. Speaker, I beg to move these amendments, and I would request Senator Sigei to second this.
Thank you very much, Mr. Speaker. I would like to congratulate the Honorable Senator Veronica Maina for this very important amendment to the Law of Succession Act. Mr. Speaker, as I second, I would like to indicate that there are 7 proposed amendments to the Law of Succession Act, and as has been ably put forward by the mover of the amendments, Mr. Speaker, of a very critical concern and appreciation is the fact that these proposed amendments will be making the Act to comply with the various pronouncements which have been made by the various courts in the process of litigation by among many Kenyans who have had challenges with the issue with regard to succession, with issue with regard to matrimonial property, with the issue with the intestacy, because this is a country where a good number of Kenyans do not leave behind wills for purposes of the estate before they pass on. And Mr. Speaker, to be very particular, the amendment seeks to align the Law of Succession Act with the Children's Act by defining what the law now with regard to who a child is. This particular introduction of a definition of a child in the Succession Act is to ensure that adopted children can fit into the estate of a deceased person, whether father or mother, and for purposes of benefiting from that particular estate. Similarly, intermeddling of the estate in this particular proposal has been broadly defined to mean taking possession of, disposing of, charging, receiving, distributing, leasing, or using property of a deceased without authority under this Act or any other applicable law. Mr. Speaker, this particular expansion of definition is seeking to support and ensure that the very many cases which we experience where upon the demise of an individual, the estate is abused by either the surviving spouse or any other person who has got an interest, particularly in situations where that particular estate could be unknown or has not been disclosed to the family, and in ensuring that we broaden this definition of what intermeddling means, we are protecting the estate so that in the event that that was not disclosed among the properties of the deceased, the family can ensure that ultimately it will be protected. It has also expanded the definition of intermeddling to mean ejecting a surviving spouse or child from the matrimonial home or any other unlawful dealing with the deceased person's estate. Mr. Speaker, this is a very important amendment because without protection of the estate of a deceased person, the beneficiaries, the children, the surviving spouse, parents, or any other dependent on that particular estate will be left with nothing to survive or to inherit, especially where the law does not define beyond the abuse or any unlawful dealing with that estate. and the proposal by Senator Veronica to expand that is highly welcome in order to make sure that we protect these particular estates. Mr. Speaker, the proposal to amend by deletion of in the Principal Act Section 32 is one that is very critical. Section 32, Mr. Speaker, in the Principal Act provides for exclusion of certain counties, the county like Kajiado, Wajir, Marsabit, Tana River, in the Principal Act has been excluded, particularly with regards to some certain immovable property and agricultural land. The Act seeks to ensure that Section 32 and 33 does not exclude those counties in the aspects of reference to matrimonial property and also in terms of succession on agricultural land as well as movable property of a deceased person. This is in effect ensuring that anyone who is living within the territory of Kenya applies this particular law for purposes of uniformity and also in terms of ensuring that we do not abuse the existence and the application of the local regulations, the local laws, or even traditional beliefs as to who is entitled to participate in sharing or benefiting from a property of the deceased. The repealing of Section 32 and 33, therefore, of the matrimonial of the Law of Succession Act has ensured that there is uniformity in the application of law across the country.